Good evening. Welcome to the Kent County Board of Adjustment meeting for March 18th, 2021. We're going to begin with the public hearing and call the public hearing to order. Will you call the roll, please?
Yes, Ms. Hudson,
Here.
Mr. Saunders,
Here.
Mr. Jenkins, Mr. Kusick,
Here.
Mr. Crossan,
Here.
Mr. Carter,
Here.
and Ms. Stenny.
Here.
Vote shows 6 present, 1 absent. We do have a quorum.
Thank you. Our counsel for this evening, Mr. Townsend, is with us on video, and I just wanted to make everyone aware of that. So at this point, will you introduce the staff, please?
Yes, thank you, Ms. Stenny. Good evening, everyone. My name is Scott Blair, and I'm one of the planners here with Kent County Planning Services. Also to my left is Ms. Jamie Fensky. She is also a planner here at Kent County Planning Services. And as the chairwoman pointed out, we have Mr. Fred Townsend online tonight, and he will serve as the board's legal counsel this evening.
Thank you. This time, I'd ask that everybody rise so we can pledge allegiance to our flag.
Allegiance to the flag.
Okay, so no additions or alterations to the agenda?
That is correct, no additions.
Okay, so can you begin the public hearing?
Yes, thank you. Good evening, ladies and gentlemen. My name again is Scott Blair, and I'll preside as the hearing officer for tonight's public hearing. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on these applications before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they please speak clearly. Furthermore, there shall be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to the other participants in this hearing, a maximum of 5 minutes will be allotted to any person who wishes to provide testimony. The chairperson of the board has the discretion to allow additional time if deemed necessary. To make a statement when your application is called, please use the podium at the front of the room. If you are participating online and wish to give testimony, please push *1 and we will unmute your line so you can speak. For the record, please give your name, address, and allow our attorney to swear you in prior to providing any testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each variance application will be as follows. First, the legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by staff. The board will then receive testimony from all those in favor of the application, followed by testimony of those who may be opposed. Once those persons in favor and those in opposition have had the opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call Kent County Planning Department tomorrow between the hours of 8 a.m. and 5 p.m. at 744-2471 or check the county's website to learn of the board's ruling. All applicants will receive written notification of the board's decision. However, this notice may not be mailed until after the next scheduled meeting. but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearing was published on the March 1st Delaware State News. In addition, all the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the application. Thank you.
Thank you. At this time, and I'll remind everybody he's online, we're going to have a statement by our counsel, the purpose of which is to help anybody here who's going to give testimony this evening an opportunity to understand a little better what is and is not considered appropriate before this particular body. Mr. Townsend?
Thank you, Ms. Denny. The test for the granting of area variances is set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty, Inc. The legal standard for area variances considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. To determine whether the exceptional practical difficulty test is met, the board must consider the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And fourth, whether failure to remove the restrictions would create unnecessary hardship or exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is met only when the difficulties alleged by the owners are practical rather than theoretical and exceptional rather than routine. The inability to improve one's business may qualify as an exceptional practical difficulty. And also, this consideration is where the board determines whether the applicant is seeking more relief than is minimally necessary to relieve the asserted difficulty. In general, the board is not to consider factors other than the ones I have listed. Therefore, those speaking both in support of and in opposition to applications are urged to present only information bearing on the 4 factors. Again, briefly, the nature of the zoning district, the characteristics of the area, whether the requested variances would seriously affect neighboring properties, and whether the applicant is confronted with challenges rising to the level of exceptional practical difficulties. In particular, presenters are instructed to exclude from their presentations any discussion of personal acrimony or disputes between the applicant and neighboring property owners, as the board is not authorized to resolve such disputes. Ms. Denny, those are my comments.
Thank you, Mr. Townsend. Okay, so now we begin, when you're ready.
First, we have application A-21-04 for Jeffrey Hawes. Do we have someone present for this application? Please raise your hand. Thank you. If you just want to remain seated while we go over everything. So we have Jeffrey Hawes. He's seeking a variance from the provision prohibiting accessory structures to dominate an area, the principal structure, to legalize finished square footage, and to enable the construction of a lean-to on an existing pole building. The property is located on the east side of Artish Drive, 0.33 miles north of Hazelville Road, west of Dover, Levy Court District 2, and Zoning District AC. You'll see here the building that has already been constructed. The applicant is asking to legalize the finished area, and along with asking for a 16 by 40 lean-to be put onto the existing pole building. You'll see that the house is 3,816 square feet, and the total proposed area for the building he's asking for is 5,344 square feet. Here's a picture of the front of the house, and you can see the accessory structure in the back. Down one side of the road and the other. Looking right on at the accessory building and the house. This is the accessory building. Down the property line. And where the proposed lean-to is going. And the rear of the home. Where the proposed lean-to is going. And the aerial. Sir, if you would like to come to the podium, state your name and address, and allow our attorney to swear you in, please.
My name is Jeffrey Haas. I live at 326 Orange Drive, Dover, Delaware.
Mr. Haas, do you affirm that the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Absolutely. Yes.
And please continue with your testimony.
Well, I came before you today for a variance that I didn't think would go this far. I actually had an architect draw my building within scope, and actually it was over, and I didn't realize it, being the roof line is considered in the square footage of the building that you're allowed to build. So from my original plan, I had to downsize it from the lean-to. I took it off. And I did not plan to do it at that point. And the upstairs of the building is an attic storage area. And in the plans, I did specifically put in there that I was going to have spray foam installation. And with spray foam installation, the building needs to be finished. It cannot be left open, unlike traditional insulation, because of a fire. It needs to be finished with drywall or what have you. So therefore, I did finish it. I put drywall in it. Well, then we put drywall, and I had the guy paint it, thinking, I really didn't think a whole lot about it. So then I had a bare plywood floor. So I proceeded. I said, well, there's splinters on it. I decided to put a cheap parquet floor down, the little snap together floating floor I put in it. And that's how I was going to leave it to be. Well, I have heat in the floor for heat in the garage, and that's all I really require. So I did want to have air conditioning in it, and I want to leave it, just basically comfortable. I'm not looking for anything other than that. So I put in a mini split system downstairs, and when they were figuring out the size for the room, it was suggested if I could put the unit upstairs. So, and I thought, I didn't really think about it, and I said, sure. And we did. So when the building inspector came to inspect the building, he went upstairs and he said, this is finished room. And I said, well, it is finished, but it's an attic. I mean, it's a clear span from one end of the building to the other. It's clear span. And he said, well, it's considered livable space now. And I thought, well, I didn't know that. But I don't really see a difference if I wanted to have climate control. And I'm not looking to do anything other than take the extreme climate from either extreme hot or extreme cold to make it comfortable, because I do have several things that I like to store and keep them preserved safely. I do not have a lot of storage in my house, so I plan to use this, and I have it, and anybody's welcome to come see it. I mean, it's a storage area. I live, my wife and I live in the house by ourselves. We don't have kids, they're all moved away. I have no intentions on having anybody live there. The garage itself, I only have a half a bath in it. There is no shower, and it's strictly a garage. And the upstairs is only going to be for storage. So that's the reason for the variance, is because now it's finished, it's over on square footage. So when I came in, when the building inspector said, you need to resubmit your plans, so I did that. I resubmitted the plans. I got a phone call stating that I'm over on square footage. So one thing led to another. I resubmitted my plans and had it all done. We had to put an egress window in the back because now it's considered livable space, which is not a problem. We can do that. So here we are. I'm asking for your, permission or approval for me to leave it the way it is. And when I submitted the plan for the variance, I wasn't going to do the lean-to, and they specifically said that, well, you're paying for this and you're going to go through the process anyway. It wouldn't hurt to ask for it. So that's why I did it. You know, it's one application fee. I asked for it, and I hope you would consider it, and I appreciate your time. Thank you. That's all I have.
Okay, so everybody's going to get a chance to ask you a few questions if they choose. So, gentlemen, madam, any questions? Comments? Okay, so I have just a couple, I guess. First of all, so ultimately, based on what you just said, the asking for a lean-to is an afterthought, and it's really not all that important in your, I mean, it wasn't something you would have thought of if they hadn't suggested if you're going to want a lean-to, you should apply for it.
Well, no, I originally wanted to do it. And like I said, originally when I submitted the plan and it was over on square footage, I took it off and redid the plan without it. And then after going through this process of the variance, it was brought back up and they said, ask for it. And that's what I'm doing.
Okay. And then, I guess this is more of a comment than a question, but the code, and I can understand when you say to me, well, what's the difference between a bare space and if it's got carpeting and painted walls and all that? Well, the difference is in the county code. And if you had intended to have what appears to be a living space up there with heating, air conditioning, carpeting, whatever, then you would have had to have gone a different route when you applied for your building permit and the process in the first place. So while you may not just understand it, there is a difference, and the difference is in the county code. So
Okay.
just so you know. So ultimately, I also, just for the record, like to make sure that the applicants are aware that the staff, the planning staff recommendation is to deny the variance to construct the lean-to. And I just wanted you, usually if they're asking for a denial, I try to get that as a matter of housekeeping into the record, okay? Were you aware that they, okay.
They did deny?
They recommend that we deny it.
Oh.
That aspect.
I didn't know that.
The lean-to, okay. So, okay. No other questions?
I'll just make one comment. So with your finished upstairs, you're now, I believe, it would be at about 888 square feet over the primary structure. And then if you added that, they consider a roof over your 40 by your lean-to, then you're adding another 640 square feet, I think, for like a total of 15. Now you're up to 1,528 square feet over. So where that lean-to is, without adding that extra space, that extra square footage, you could put a nice patio, you could put an retractable awning, you could do a number of things that would give you kind of the same effect as the lean-to, depending on what your uses are for it. But by adding that lean-to, you're really bumping up going over what you're already over. So
I didn't realize it was that number, honestly, I didn't. But it is.
Can you talk to us about what the lean-to is going to be used for?
Just a patio, that's it. I actually, I'm not saying I will, but I thought about putting a pool in the future if I could do it, and I don't know that. So I don't know if I really want to have a pool yet. My wife wants it, but I don't know if I do. I don't want a job.
By the way, the addition, the building is beautiful. Did a
Thank you.
nice job.
Thank you.
Uh, Put a patio. If, and, you know, everybody gets to vote here, so I'm not even not a suggestion. But should it end up being a patio, roof over it, that's, then it becomes something else, just for your
I understand
information.
that.
If you attach a roof to this.
That's all I want it to be.
Okay, okay. No, nothing else. Okay, thank you.
Thank you. Thank you very much. I appreciate it.
Is there anyone else in favor of the application? Please come up to the podium and state your name and address and allow our attorney to swear you in, please.
Hi, my name is Lisa Haas, and I'm Jeff's wife. I'm at 326 Artist Drive, Dover, Delaware.
Ms. Haas, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
You may continue.
We are just trying to, we didn't realize what we did upstairs when we put the heating and air conditioning up there. We were just trying to have a controlled environment to preserve pictures and things like that we want to store because we have no storage in the home. So we just asking if we could have this approved is all.
Answer this witness.
I would like to add something, what Ms. Denny said earlier. The staff recommended a denial for the lean-to, but did recommend approval for the finished attic.
Anybody else? Thank you.
Thank you for your time.
Is there anyone else here in favor of this application? If there's anyone on the line, please press *1 to unmute your phone. Is there anyone here in opposition of this application? If there's anyone on the phone that's in opposition of this application, please press *1 now to unmute your phone. Seeing no one, we will move forward to the next application.
Before you do that, could I just interject? This, and I may have the wrong application, but this correspondence that we received from Kim Woo Mai, that's the next case? Okay, good enough. I just wanted to be sure.
The next case, yep.
Okay.
Next, we have application A-21-05. Is there someone here to represent this application? Thank you, sir. We have application A-21-05 for 49 Pines Estates, LP. They are seeking a variance from the required 25-foot rear setback to legalize an existing single-family dwelling. The property is located on the northeast corner of the intersection of 49 Pines Drive and Cross Pines Drive, approximately 199 feet west of Clearstream Drive, being Lot 64 of 49 Pines subdivision, west of Dover, Levy Court District 2 and Zoning District AR. Here you will see the plot plan that was submitted for the request. And you will see the rear property line is the one on the bottom of the screen, and the side property line is the one to the right of the screen. And this property would have two fronts because it's on a corner property. Here's looking front of the house, into the development, back towards the front of the development, down the other side, down the rear, on the other side of the property, and the aerial. The aerial doesn't show the home at this time. Sir, if you want to come up to the podium and state your name and address for the record and allow our attorney to swear you in, please.
Oh,
Okay.
I'm sorry.
That's okay.
I was waiting for him. Doug Liberman with Larson Engineering, 910 South Chapel Street, Newark, Delaware.
Sir, do you solemnly swear that testimony given in this proceeding, or I should say, do you swear or affirm the testimony given in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Please
Okay.
proceed.
Thank you. Commission members, my name Doug Liberman. As I said, we're here seeking a variance from section 205-397-.2.c of the Kent County Code to decrease the rear setback from 25 feet to 17 feet, 17.1 feet. The house was constructed, was placed at this location due to a mistake on my part as a misinterpretation of the Kent County Code to locate the rear yard setback. It was my understanding the rear yard setback was based off of opposite the face that the house was facing. So the house ended up being constructed over what would be the rear setback line in this area. With this lot being almost completely square, it's about 6 feet longer in the direction where we put the house to determine where the rear setback goes. So it was the intent of Wilkinson Homes, the builder, to have Lot 64 face 49 Pines Drive as opposed to Cross Pines Drive, to create a consistent street view and presentation of the front of the homes rather than the side of one home with all the corner home sites at the intersection facing the same direction. This house would fit on the lot with the correct rear setback, so they did not get a larger house on the lot than what they would have if they had placed a house, we had placed a house correctly within the site. So there was no benefit with where the house was placed. We prepared the administrative variance request and submitted it as soon as we were alerted to the issue. Two homeowners provided objections to the variance. The builder tried to negotiate with the property owners prior to the need to file the full Board of Adjustment application variance hearing request. They had a couple meetings with the homeowners, and in an effort to resolve the issue, however, the resolution was not reached or mutually agreed upon in a timely manner to be beneficial. So therefore, we're at tonight's hearing. There was a third objection. I believe Ms. Denny had mentioned that came in after the original administrative variance. It came in prior to the hearing, after the public notice had gone up. We prepared a letter that was submitted in your packet to address the 4 criteria that Mr. Townsend had mentioned. So I'd like to go over that now, if I could. Number 1, the nature of the zone where the property lies. The property lies within a residential zoning district where all the surrounding properties are residential. Number 2, the character and uses immediately adjacent in the vicinity of the property. Property lies within an approved subdivision of 49 Pines where all the surrounding properties are residential, so it matches the character and uses of the area. Where the removal of the restriction on the applicant's property would seriously affect neighboring properties, removal of the restriction would not affect the neighboring properties or alter the character of the neighborhood. The house was constructed to face 49 Pines Drive. The rear setback location is essentially a side setback when looking at the property as it sits on the lot and within the subdivision. The setback of 17.1 feet for the subject property on to this adjoining lot line is more than several side yard setbacks and that other properties maintain. For instance, Lot 63, the property directly adjacent to where we're asking for the variance, has a setback of 11 feet on that side, and on their opposite side is 10.4 feet. So the setback that we provide on that side is larger than what we see here for the adjoining property. And if we look at the drawing that I presented of the actual subdivision itself of the adjoining properties,
I don't think we
It was
have
part of
that.
my,
It was,
it
sorry.
was the
that
11
in
by
their
17
package.
that's in your face. In your packet, there's 20 setbacks that are shown on there for the houses that are in the vicinity. 15 of those setbacks are less than the 17.1 setback that we are asking for. So I believe what we're asking for matches the character of the area. And there you go, that's a good picture of what we prepared a picture of to show the 17.1 setback on the left and the 11 foot setback on the right. Number 4, whether failure to remove the restriction would create unnecessary hardship or exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements on the property. The exceptional practical difficulty is that the economic hardship to the owner or the builder, in this case, to resolve the encroachment into the rear setback would far outweigh any perceived hardship to the adjoining property owners. As previously stated, this setback is larger than most side yard setbacks along the street and is consistent with the character and appearance of the neighborhood. So we have these pictures that we have marked up that shows a couple properties within the neighborhood. So you can see this is lot 63 on the left, lot 62 on the right. Those setbacks in that area are 11 and I believe 14 feet 2 inches. The next one is lot 13 and lot 12. This is a view of the subject site across the lot 12, who was one of the lots that objected to the variance. Again, this shows the setbacks on this existing lot are actually smaller than what we are providing on lot 64. Lot 12 has a 10.4 foot setback, and then lot 13, which is directly adjacent to that house, has a 10.8 foot setback. Go to the next one. This shows the subject site on the left. Oh, no, that's not the one there. Okay. That is, this is just a representative setback of nearby lots, lot 17 and 16, which is a little bit further down, 49 Pines. We've got 11 and 11 and a half. And the next one shows lot 19 and 18. Again, we've got a 10.4 and a 15.1 setback there. And the last one is lot 20 and lot 19, which is 11.3 and 10.4. If we could go back, I wanted to go over one real quick. Gene, next one, next one. Okay, this is the view standing on lot 13, looking across at lot 63 on the left, or I'm sorry, 64 on the left and 63 on the right. Lot 12 had objected to this. Lot 12 is the grass area to the left of the pole. So we wanted to get a shot, which is about the front face of the adjoining property, which is right about where lot 12 and 13 are looking across. And there's really no effect to what would be the view of lot 12 on to this area caused by that setback, and the house being constructed in the wrong location. So I believe we have shown the exceptional practical difficulty to grant the variance with the information provided. Staff has noted several variances in the area that were granted, for the most part, to exceed this variance. And we're all for variances were for things people wanted to build, not something that was created by a mistake. Staff has recommended approval of this variance in the packet that was provided. This variance is a result of a mistake, not asking for something that could not have been constructed without the relief, because the house would have fit on the lot within the building envelope originally prescribed by the record plan. So if you have any questions,
Anybody, questions?
Do you have any idea of what types of options or ideas were presented by the builder to the owners that objected to try and rectify that situation?
I believe they had talked to two of the owners, and there was a monetary resolution that they were working on with both, but I don't believe that they came into an exact something that would work for everybody on that.
Anybody else?
Yeah, do you guys still own the property? I seen there was a sold sign.
Wilkinson, I believe, still owns the property. I'm not sure if it has transferred as of yet.
Anybody else? So my question is, and I did not go look at this, which is rare, but I didn't. So when you look at the house on 65 and 64, and then the one across the street, there they all face that one, the street, do they both face Cross Pines Drive? And this one,
So-
the side?
65 would be behind 64 here.
Right.
It would face Cross Pines.
And does it, and it face side street, or does it face Cross Pines Drive?
It would face,
And if it's helpful, what I'm trying to get at is if you're driving Pine Drive, or,
oh, I'm sorry, 65 does face Cross Pines Drive.
it
yes.
does?
Yeah.
Okay.
Now,
And this one faces 49 Pines Drive, and then the
Correct.
one across the street?
one across.
Thank you, that's very helpful. I guess I have what I want now. Because what I'm asking, what I'm trying to get at is if you're driving down Cross Pines Drive and all but one house face Cross Pine Drives, and then you have this with the side facing, and that's my question. So, but I've just, and that's, so,
Which
I
one?
think the primary reason was 49 Pines is the main drag into the subdivision. That's the entrance out onto West Denny Road. So when you come in to the subdivision and you drive down 49 Pines Drive, all the houses on 49 Pines face 49 Pines. So, you know, with lot 64, if it was facing Cross Pines Drive, you'd be driving down, looking at the side of the house,
okay,
as opposed, and into their backyard, where
Okay.
in this situation, the front of the house faces 49 Pines Drive and kind of blocks the backyard. I think it creates a little more privacy for all the houses that are on 49 Pines.
okay. So you've answered my question. I just wanted to try and visualize, because, and interestingly enough, we don't have a picture in that direction. But you know, is this, I just was wondering if this was like the odd man out with just the,
No, it's not.
so, okay, but see, the house behind is not done, and I
Right,
can't really
it is
tell if
facing,
that's,
yeah. I believe
okay.
those
So that's the back, when I'm looking past the gray house, the one
other house,
behind it,
You're looking at the side of
I'm
that other-
looking
side
at
of
the
lot
side
65.
of the one.
Correct, of lot 65.
Okay,
But again, that's, there's only 64, 65, and then I believe 66. And then we have another street that comes down the other way. So, yeah, 65 does kind of stand out on its own. But again, the primary drive into the site is 49 Pines Drive, and that is the view shed that everybody wanted to maintain.
okay.
All right, thank you.
Is there anyone else here who wants to speak in favor of this application? There's anyone on the line that would like to speak in favor of this application, please press *1 now to unmute your phones. Is there anyone here in opposition of this application that would like to speak? Please come to the podium and state your name and address for the record and allow our attorney to swear you in.
Okay, we can only have one person at a time up to the podium. I'm sorry, but you'll have your chance, but just one at a time, please.
All right. My name is Tasha Olfis. I live at 689 Harvest Grove Trail. It's my mother's property that I'm here to speak on behalf of, and she lives at 149 49 Pines Drive.
Ma'am, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, please proceed.
Okay. So my mother bought her house in September of 2020, and based on the purchase of her house, she bought approximately 1/3 of an acre that was obviously to be unobstructed, unencroached upon, and, you know, she was going to apparently live happily ever after, as everybody plans on doing when they buy their house. She subsequently receives a letter requesting an administrative variance, essentially because, as the previous gentleman just explained, that there was an error in his estimation in terms of what the Kent County Code was in constructing the home adjacent to my mother. So effectively, they turned the house. In layman's terms, they turned the house from facing Crossview Drive to 49 Pines. And I do agree, the house does look better facing 49 Pines. However, unfortunately, due to a misinterpretation of the code, it has impacted my mom's property because there is an encroachment of almost 7 feet. Okay? And so we have been, you know, Mr. Wilkinson reached out to my mom and myself. We had a meeting. Mr. Wilkinson has acknowledged that it potentially, not directly, but it potentially could impact my mom's value by making some offers to increase my mom's value, because our concern and our initial objection was, listen, there's an encroachment on my mom's property. If and when she decides to sell her home, that could impact resale value. I do understand that there are other encroachments, there are other, I guess what he was explaining a moment ago is that, hey, there are some other setbacks that are similar to other homes in the development. It will not impact the look and appearance and the feel of the neighborhood. However, my mother bought what she bought. She bought 1/3 an acre, unencroached. Those other homes may or may not have done that, right? They didn't have an encroachment on their property. They didn't get an administrative variance in the mail, and they're not here today to testify on their own individual properties. We are. I'm not worried about those other homeowners and what they did or did not experience. She bought 1/3 of an acre that should have been unencroached upon. It's not her fault that an error was made with their engineer. So, you know, yes, we had been in talks with Mr. Wilkinson, with the builder, basically, in regards to compensation. We simply haven't heard back. That's neither here nor there for this particular hearing. We just simply have not heard back from his attorney, and our attorney is handling that. But pretty much, that's pretty much what we wanted to really state here today, was just the reasons for our objection. Our attorney has been in touch with other real estate professionals in the area to validate or not as to whether or not it would impact resale value. And the answer is yes, it could, in his professional opinion. And that's what we have been told, and which is why we are talking with Wilkinson's attorneys. So yes, it will impact her resale value if and when she does decide to sell the home. And so those decisions with regards to, the attorneys, which again is not for our discussion here today, that is still continuing. There is going to be an impact. So I appreciate, the comments about the look and the feel of the other houses and all the other setbacks that have been made for all those other properties. Not our concern. We're talking about her property, her address, what has happened here between these two homes, what she bought, and what she's entitled to, quite frankly. So, that's our position. I'm not sure if my mother has additional comments or if you guys have questions that I can help answer. I'd be happy
Okay,
for
well,
you
let's
guys to consider.
let's start just with seeing if there's questions for you. Anybody, questions for this lady? Okay, so my question would be, and you're absolutely right. Whatever type of a settlement outside of this you come up with, that's a private matter, and it really doesn't affect us. I mean, it does sound like they have reached out to you to try and resolve some of the value issues, and I understand that.
Sure.
But like you said, so we really, that's not,
Of course.
part of us. But so when I look at these two houses and you see the property line, your mother's objection is that, of course, more narrow at the front and wider at the back. She's losing that part of that land. Is that?
It's
the
almost
house?
7 feet from the side, almost 7 feet, from what I understand, from the side of the house is the amount of the encroachment.
Okay.
I have a question.
Ms. Denny?
Yeah, I'm trying to do some math here, but go ahead. Sure. Go ahead, Fred, you might answer my question.
Okay. So just for the record, I think everybody probably understands that we don't have an encroachment on the neighbor's property. To use the word encroachment correctly would be in the context of an encroachment of the house into the setback, but there's no actual encroachment onto the neighbor's property. I think everybody understands that, but I just felt the need to say it on the record.
Actually, I was just trying to do the math to be able to say, okay, so the distance, the land is the same. She's not encroaching on one or other. It's just that the house was built closer to your house, and the appearance is that. I mean,
The
it's
house
not
is built.
illegal.
Right, it's, right, so she's
7
not
feet,
over
7
our property
feet.
line. Right, she is not over my mother's property line by 7 feet.
She's just
She's just
7
closer-
feet closer to your mother's house.
By 7 feet, correct. Yeah.
Okay.
Still 18 feet.
Right.
And it's not, so that truly legally, and I was trying to do the math because I'm thinking, well, I'm not seeing that, but I wanted to be sure before I spoke, and Mr. Townsend saved me there. But, so just as a matter of housekeeping and for the record, it's not truly an encroachment. It's just that the houses are closer together. And I'm just saying that for housekeeping matters because, if somebody reads the minutes, we don't want it to appear as it's a legal encroachment. It's just that your mother's house is 7 feet closer to the house next door, or the house next door, I guess, is 7 feet closer to your mother's.
There you go.
Okay.
Yeah.
All right, so now, you had something. Okay.
Quick question. So I'm not sure in your development there if they're allowed or not, but if you were to put a fence up between the two, which I think many homes do, and if they're allowed in those subdivisions, from your mom's house, she'd still be seeing her 25 feet or whatever the number is. You wouldn't be able to see that the other side was even 7 feet difference. And the other question I would have is, your mom's house is the one on the left?
It is the beige, the one, I guess it's to the right in this photo.
Oh.
The beige house.
That's hers there.
Right.
She's the beige. Mhm.
Okay.
Yeah, and the fence was an offer that Wilkinson made, but again, that's part of, conversation. So, but we have not heard back from his attorneys at all.
So the
Denny, I
real
have
estate
another
professional,
question, if I could.
the real estate professionals that you spoke to, we don't have,
Our attorney?
No, I think you said maybe you talked to some real estate professionals about the value, determining the
Yeah,
value.
the attorney had talked to
Right. So
his.
what was their opinion that would decrease, possibly decrease, would not, it's not definitive, but would possibly decrease her house if she were to go to sell it?
Well, yeah, I mean, he was just saying to us that, yes, it could potentially impact resale. He didn't say, it's hard to predict, obviously, by how much today, based on, 10, 15 years from today. But, yeah, he had been in touch with his real estate. I don't know who they were. But, I just wanted to reach out to a professional as opposed to making just invalidated claim or non-validated claims. I'm not going to do something like that, but he did do some due diligence on his side, and that's what he came up with.
Okay, Mr. Townsend, you did have something.
Right. So this is I guess a question for the objector. What is evident from your mother's house is that there looks like a bank of 2 windows and then another window on her home. And across the way there, directly across from those windows, is the garage. And the garage of the house that's not compliant doesn't have any windows, at least on the area there that we can see. But the main part of the house is inset from the garage, and I presume there are windows on that side. Is that right?
I don't know if there's windows on that side. I would assume there would be. No, guess not.
Yeah. There are no windows.
There's a rear
yeah.
window upstairs.
Well, I don't think we have a picture of it. So my question was going to be, how do those windows line up? And of course, they're inset quite a distance. I presume that part of the main house is within the rear yard setback. You may not know the answer to that, but staff may.
Yes, so that section meets the setback that we're looking at there in that picture.
So my questions are going not so much to the appearance and the effect of the appearance of the house vis-a-vis the neighbor who's objecting, but whether there are privacy concerns. Oh, so it's a straight wall then from the garage all the way back? Is that right?
Yes, with a slight bump out there.
Bump out for the gas fireplace.
Oh, okay, I see the bump out. All right. So the concerns are more related to the proximity of the house than are related to privacy concerns.
Mm-hmm. Correct.
Okay. I don't have anything more.
Okay, so to be clear, had that house, had the house just been pushed back up to that red line and just up against where it says upside down, whatever it says, but if it had just been pushed up, then it would still be in the same place, but it would just be further up and there'd be more room between the 2 yards. And I guess that's your objection more than if it had been turned around and you're looking at their backyard?
Yeah, we wouldn't have wanted that.
No, because
I do agree that the house should have been turned. I do think that was the right call. It is just that the house was built closer. So I guess I think what you were saying, just so I'm clear, is your question, I thought you were saying if the house were built up closer to the street.
No,
Would we
up
still have the same
closer
concern?
to,
Clearview?
Cross Pondsburg
Cross-
Drive.
Yeah.
to cross, yeah. Yeah, Cross Pines. So in other words, when I'm looking at this, can you see this? It's up there, but just moving this from here to
Yeah, a little bit.
the 7 feet. But I guess my question, and the reason I'm pointing this out, is the view, it would only be back further. The view would be that your mother would be looking at from her windows would be exactly the same. It would just be a little further away.
Sure, we're not concerned about the view.
Okay,
That's not our concern.
okay. Anybody else?
Yeah, so I mean, there is a hardship to just move this house 7 feet to get it within the building restriction line. They pretty much got to tear down the whole thing. And at that point, they could build it wherever they want within that buildable area. And they can turn it the other way.
I'm just so
So it just-
confused as to how this house got constructed without,
It was
it being
good-
caught mid-construction.
It's a unique lot. So typical side setbacks is 10 foot. So this is a unique lot. Just was missed.
It is unique in that when you have a corner lot, like if you have houses next to each other, the setback is a setback is a setback, front and back. But when it hits the corner, then they consider, even though it looks like the side of the house, it's considered, it's either way, it's like the same setback. So the setbacks change. We get these from time to, this type of an application from time to time. So I don't want to say it's the norm, but it has happened in the past. At this point, anything else, anybody else? Thank you so much. You're very
Thank
clear.
you guys for
and
your
that's helpful.
consideration. I don't know if you have.
If your mother did want to say something, she's welcome. Good daughter.
Is there anyone else in opposition that would like to speak? Please come to the podium and state your name and address for the record and allow our attorney to swear you in.
Good evening. My name is Dr. Nicole S. Harris, and I live at 13449 Pines Drive in Dover.
Ma'am, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Please proceed.
I am the home the engineer was referring to as Lot 12. I am across the street. I started my process in building my home in July of 2019. At that time, I had an option of picking several lots, including this lot here that is in question. And I was able to see what the plans of the development were. And I got to see this house being built incorrectly because I had seen the plans of the houses in the area and had my choice of pickings. When I decided to go to the development, there was only one house being constructed and there were no streets. So it was very, very, very new. And I just feel that the character and the way the house is built, as you all have discussed, I understand since she's next door, my neighbor is next door, it's an encroachment, but this house is literally, was supposed to be the same size lot as my own. And I had the choice of getting that lot or the other, but I didn't want my house sideways. But I preferred the house being sideways because now it looks directly into my house. Everything, the windows, the doors, the garage, you can't come out at the same time. Everything is directly facing me and looking directly straight at me. And with the house being sideways, in which unfortunately he mentioned that all the houses are facing forward, and they're not, because if you go to the end of the block where we get our mail, the house on the end is faced sideways, like this house was supposed to be based on the original construction of the plans of the development. So I did want to clarify that. And it does affect property values because of the sizing of the lot and how much space and how much grass, and if they want to put up a fence, it does make it look larger, and it does take away from the property value of the other homes that are in that area. And the change in the scale to me, I mean, again, this is my opinion, and since you object and you provide your comments and provide your own opinion, it does look extensive to me because if you saw, this is 17.1 as opposed to my home has 11. And I would have loved to know if I could have put in a variance. I would have loved a bigger home. That's why I got the end. But I thought the lots were identical. They're not. And I can see that they are now, I think it's more so, to me, unfortunate that the house was built and knowing that it was built incorrectly. I knew it was built incorrectly because I was informed of what the houses were going to look like in the development. So I just thought that I would add that, and that was my main objection. Wilkerson did reach out to me. They reached out to me, and I had my attorney reach back to them. They didn't talk to me anymore after I submitted information to them of my concerns. So I don't know if that means anything, but I thought I'd add that to the record.
Thank you, Dr. Hurst. Anybody have any questions or comments for? Thank you.
Thank you.
Is there anyone else that would like to speak in objection to this application? If there's anyone on the line, please press *1 to unmute your phone. There's no one.
Okay, so I guess then that's the end of this of the public hearing. So does anybody need a break, or do you just want to continue on? Everybody's good? I thought I heard somebody say it. We'll take a break. Okay, so at this point then, the public hearing is ended, and we will now call to order the business meeting for March 18th, 2021. And I'm looking for my paperwork. So the first, so even though we didn't leave, I just like housekeeping. Let's call the roll, please.
Sure, Ms. Denny, call the roll. Ms. Hudson.
Here.
Mr. Saunders.
Here.
Mr. Kusick.
Here.
Mr. Crossan.
Here.
Mr. Carter.
Here.
And Ms. Denny.
Here.
A vote shows we still have 6 present of 6 and continue to have a quorum.
Thank you. So first order of business this evening is the minutes from the February 18th, 2021 meeting. So I need a motion.
Crossan, I'll make a motion that we approve the minutes from the February 18, 2021 meeting as presented.
I second.
We have a motion and a second. All in favor?
Aye.
Aye.
Any nays?
Please mark me as not voted.
So having received, all the votes, the business meeting minutes, can't talk, of February 18th are hereby approved. The next order of business is the notice of decisions from the February 18th meeting, of which there is one, which is A2102. So we'll need
Again, I'll make a motion, Crossan, that we approve the notice of decision from February 18, 2021 meeting. It was A2102 as presented.
I second.
Okay, if we have a motion, a second, all in favor?
Aye.
Aye.
Any nays? Okay, having unanimous votes, notice of decisions are hereby approved. So we have no old business, and so at this point, we are going to go to new business. It looks to me like everybody's here for both. So let's begin with 04. Any discussion, any thoughts, or motion?
Crossan, I'll make a motion. I make a motion for A-21-04, that the board approves the variance to allow a legalization of the 960 square foot finished area and denial of the variance to construct the 640-foot lean-to on the existing building. The reasons, I believe, are that there is an exceptional practical difficulty in the having to remove what's been done upstairs, and the fact that it is going to be used for storage purposes and not as a residence. The improvements that were made inside the building have no effect on any neighboring properties and would not have any serious effect on any neighboring properties, and it doesn't change the character in which it was meant for. As far as the reason for denial on the lean-to is that it is not needed, number one, for any particular reason. There are several alternatives to provide the same, whatever the reasons were for the lean-to, such as a patio or and a retractable awning. You could actually even put a separate screen building there and not affect the, I believe, and not affect the square footage of the existing building. So for those reasons, that's my motion.
Second.
Okay, so we have a motion, a second. Anybody have any comments or discussion? Okay, so let's call the roll.
Mr. Kusick.
I vote yes to that motion to approve the variance for application A21-04 to approve the variance to allow for the legalization of 960 square foot of the finished area. Pretty much what Mr. Cross has said. It's not affecting any neighboring properties. The economic hardship is there. He put the time and effort into creating that space, so, and it's not no harm on the community at all. And then also for the denial of the 640 square feet lean-to, same as what Mr. Cross has said. There's really no reason that he needs it. Need the patio, and it really exceeds the square foot limit per the code.
Thank you. Mr. Saunders.
Yes, I am the same. I approve A-21-14 for the room upstairs, but also in denial of the lean-to. And I do believe where the building's at and everything, I don't think it changes the character or the immediate vicinity, or whether that restriction would affect anybody else's property.
Thank you. Ms. Hudson.
For A-21-04, I vote yes to the motion to approve and legalization of the 960 square foot finished area in the attic. The nature of the zone does not change, the character does not change, the zone does not change. You can't tell the difference if it is finished or if it isn't finished from the outside. And I vote to deny the lean-to because a patio could be provided and it wasn't desired from the applicant.
Thank you. Mr. Carter.
I vote yes to approve the motion on A21-04 based on the board or the staff recommendation and the testimony tonight.
Thank you. Mr. Carlson.
I vote to approve the legalization of the finished area and the denial of the 640 square foot lean-to based on my motion.
Thank you. Ms. Denny.
I vote to approve the motion. I definitely think that I do not see any exceptional practical difficulty whatsoever that would lend itself to that to being able to add the lean-to. I think that just will add to the to the dilemma of needing a variance in the first place. It just doesn't fit the code, and it shouldn't. As far as and again, being very careful, because I do not like to set precedents here when I vote, but I feel that as long as it's not ever occupied, the 960 square foot finished area isn't harming anything, can't be seen from the outside, but I certainly think it'll be a nice little dilemma someday if the attorneys, if they go to sell this property and try to sell it as a finished room. But, again, therefore I vote yes.
Thank you. For A2104, on a motion by Mr. Crossan to approve the finished area and deny the request for a lean-to, we have 6 yeas and 0 nays.
Having received unanimous positive votes, application A2104 is approved for the 960 square foot finished area and denied for the construction of a 640 square foot lean-to.
Okay, the next application up for discussion is A2105, 49 Pines.
Okay, any thoughts or just discussion? Or a motion? I'm just going to say this. This is really difficult for me, and we see these once in a while, and, you know, I'm not big on the don't ask, apologize way of doing things. And again, you know, we had testimony before us tonight that that a neighboring property, that where they bought the house knowing, considering, thinking about the placement of that house directly across the street. And again, while the view would not be any different for the property owner looking out of the window, you're still seeing the side of a building, but there's also potential with a little more distance to have plantings and shrubbery and other things. You know, I mean, the code provided that much space, and again, it's not encroaching on our property at all, and I understand that, but it just, I do think that it's very sad, especially when we have the neighbor directly across the street saying she planned everything, chose the lot she chose and everything, knowing that house would be in a different direction. Other than that, I'm open for a motion.
I have a question for staff. So if these plans were submitted before any of the houses were built with the intention of building the house facing that way, would he still need a variance or would it be the traditional 10-foot setback?
The setbacks would still be the same no matter which way the house is facing.
Okay, so we have to do something, gentlemen, lady, madam. I'm so used to it. Used to be all guys. And again, there's the part of you that says, I don't know, there's just a part of me that says it's absolutely not appropriate for this to have been done this way. You know, and again, I'm sure that the, footer inspections and all that, It's just the way, it's just how it happened, and it just seems very unfair to the property owner and to the neighbor.
I'm going to make a motion to approve A 21-05 based on the staff recommendation and the discussion tonight. Probably the biggest problem with this is the cure is going to far outweigh any impact that this might have.
Right ahead.
Could we do a conditional approval? Like have the builder put a fence or make sure he puts a fence up? Is that, I think that'd be more of a question
I
for
think
Fred.
that's a discussion for somebody else to.
Yep, Miss Denny, we've got a motion, so we'll need a second.
We need a
second
second
Then
before
we
we can
can
discuss
entertain
it.
deliberations.
I'll second that motion.
So we have a motion and a second. We've heard your question, unless you want to, and as Mr. Carter stated, that we don't even know if this homeowner would like to have a fence. Maybe she's opposed to a fence, and so that's a discussion between their counsel and, okay. All right, so we have a motion and a second, and that motion is for approval. Call the roll.
Thank you. Mr. Saunders?
Yes. A-21-05, I am to approve, based upon the testimony, understanding that the difference, when you're looking at it, there wasn't a view problem, there wasn't anything else when you look down from the side. Granted, there was a mistake made, but the exceptional practical difficulty for the builder, it'd be the same thing. It'd be extreme just to move a couple of feet.
Thank you. Mr. Crossan?
I also vote to approve A 2105 based on the staff's recommendations and whether to remove the restriction on the application's property would seriously affect the neighboring property or properties. It looked like it could affect it in some way, but I'm not sure how serious. It is a 7-foot difference in a 25-foot setback. And certainly the hardship on the builder to tear the house down or to cut it 7 feet off, if it's not practical, would not be feasible.
Thank you. Ms. Hudson?
For A-21-05, I vote to approve based on staff recommendation. The nature of the zone does not change. The character and the use of the zone does not change. And it's truly a unique situation, and I just want to make sure there's no, to put, like Ms. Denny says, set of precedents that builders can mess up and then just receive a variance. That is really, truly unique, and it's unnecessary hardship due to the builder to tear down the house, move it 7 feet. Thank you.
Thank you. Mr. Kusick?
I vote yes to the motion to approve application A21-05 per staff recommendation. This does not alter the character of the neighborhood. The economic hardship is clear. The side setback is larger than most of the setbacks that are currently there.
Thank you. Mr. Carter?
I vote yes based on the staff recommendation and my motion.
Thank you. And Ms. Denny?
Okay, well, I'm going to vote no because architect builder error doesn't feel like an exceptional practical difficulty to me. And And again, it may not have an impact on all the houses in the development or the character of that particular little neighborhood, but it certainly had an impact on Dr. Harris. And she stood here and gave testimony to that tonight. And I'm voting no because I think sometimes this don't ask, apologize stuff just has to stop. And again, we see it from time to time. So there's my speech for the night.
Thank you, Ms. Denny. We have 5 on A2105. We have 5 yeas and 1 nay on a motion to approve the variance.
Having received the required amount of positive votes, application A2105 is hereby approved. We're looking for a motion to adjourn.
Motion, we adjourn.
Second.
Motion is second, all in favor?
Aye.
Aye.
We're adjourned.
Conference recording has stopped.